Debbie Templeton.
Matthew Mazza.
We will be presenting on Engel versus Vitale, which was the 1962 Supreme Court case that was debated whether public schools should be allowed to say generic prayer. Overall, the decision declared school-sponsored prayer in public schools unconstitutional and should not be practiced. I will cover the parties involved in legal issues with the case, while Matthew will discuss the facts and our personal opinion of the case. Parties involved. There were two major parties involved. The first is Stephen Engel. He was the father who opposed the prayer at the start of the day. Engel, who joined with a group of other parents, believed that any sort of prayer, even if it was voluntary and non-denominational, should not be allowed by a public school as it crosses the line between church and state. Stephen and the other parents opposing were about protecting religious freedom and ensuring government neutrality in religious matters. The other person involved was William Vitale. William Vitale was the president of the school board. He supported the prayer and argued that the prayer was intended to promote moral value and was not meant to impose a specific religious belief on students. William was all about promoting moral values and unity. Vitale is depicted on the right, and Stephen Engel is represented with the picture on the left. And there was also a Supreme Court majority, and their names are listed below.
Some facts about this case is that in New York State public schools, to start each day, they said the Pledge of Allegiance, and then they followed with the non-denominational prayer, which read, Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us, our parents, our teachers, and our community. Though there was an opportunity for students to opt out should they or their families had disagreed with the prayer, Engel still had reason not to like it. He then went on to sue on behalf of his child. The New York State Supreme Court agreed with the school board, saying that the prayer was okay. The Supreme Court was the first court to hear the case. It then went to the New York State Supreme Court Appellate Division, which yielded the same result. Then it traveled to the New York State Court of Appeals, where the decision was once again solidified. It then reached the United States Supreme Court.
Legal issues. The legal issue centers on the First Amendment of the Establishment Clause, which aims to keep government entities from endorsing any religion. The First Amendment Establishment Clause states clearly that Congress shall make no law respecting an establishment of religion or the prohibition the free speech of religion. Essentially, the court had to decide if a voluntary prayer goes against the constitutional separation between church and state.
After eventually reaching the Supreme Court, the decision was marked as unconstitutional, saying that as it had referenced God's blessing, that would be considered enough of an endorsement of religion and violate the Establishment Clause in the First Amendment.
It is important to note that the court wanted to make sure that all students, regardless of their beliefs, felt equally welcome and that no one would feel pressure to join in a religious practice. This case set a boundary showing that even a small mention of religious language such as God's blessing in a government setting can be seen as favoring religion.
Our opinion with this court case is that we do agree with the court's decision. We believe that even a voluntary prayer in public schools could make some students feel pressured and create a sense of peer pressure that could result in not appropriate school conversation for students, especially those that are in the younger grades, elementary and middle school. We also looked at it from a legal context, and from the very beginning, the Founding Fathers were very deliberate in how they made the Constitution. We were able to see throughout history throughout times of slavery, in this 1962 court case, and even present-day Supreme Court cases, that how they made the Constitution would assist in acknowledging some of our freedoms. And with that, they placed a heavy emphasis on the states' rights. Firstly, they separated the two governments, state and federal government. And then in terms of church, they kept that out of the picture altogether. And Thomas Jefferson specifically was accredited with that, separating church and state. And to have a country where freedoms like this do exist, it was evident that it was the right decision during the constitutional conventions, and it remains the right decision today to separate church and state. Also, specifically understanding the Establishment Clause of the First Amendment, it is worded in a way that a government cannot endorse or respect a religion, which we believe would make this decision by the courts the correct decision. Though this prayer was non-denominational, though it was a generic use of words, it did use the word God, and that would infer that it was a Christian or a Jewish prayer, as those are two of the most prominent God-following religions. Now, especially for young students, this could lessen other world religions that do not focus around one God, or the religions that do not call their creator God. And it would also be offensive to the lack of religion if a student should believe in atheistic views. Of course, as Christian students, Dovey and I both hold prayer to a very high daily practice, and we both would encourage students of all ages and all of the different religions to pray with their families, in their friend groups, in private schools, and with their church community. However, understanding how the law is written and how we believe it was meant to be interpreted, understand the setting in which this case was set, we do agree ultimately with the Supreme Court's ruling. Comparing to a different case, we chose to compare it to Everson versus Board of Education, which focused on the same issue, the First Amendment's Establishment Clause, and how it played a role in whether or not the Board of Education, in this case it was a New Jersey Board of Education, were they playing a hand in endorsing a religion. What happened in this case was that the Board of Education was reimbursing travel expenses for students that go to religious schools. Taxpayers sued, arguing that this policy was in fact endorsing a religion, and the court ruled that it did not violate the Constitution in this stance. Though there was religion involved, the practice of simply compensating for travel was secular in itself. Therefore, there was no blatant endorsement or reward in choosing a religious school over a public school, and that caused the Supreme Court majority, only a 5-4 ruling, to go to lean with the Board of Education. This case was 15 years prior to the case that we studied, Engel versus Vitale, but it did set an important precedent on the Establishment Clause going forward. And as we, read through our case and compared it to this case, we do believe that even though there was a flip in a ruling where they said that this did not violate, and for our case it did violate, we do agree that the decisions were fair, and the interpretation of the Establishment Clause was not only the correct decision, but it was a consistent decision, and that this was secular enough, the school prayer was not secular enough, and that is the basis of which they made these two rulings. In closing, we learned that a case that originally was seen by 3 New York State courts was eventually struck down at the United States Supreme Court level. This case involved the legality of school prayer, which was determined unconstitutional as a public school practice. We then also learned how it compared to an earlier court case involving very similar legal issue.
Engel versus Vitale set an important precedent by ruling that even voluntary prayer can violate the Establishment Clause. The court made it clear that public schools should avoid any form of religious endorsement. This decision has been used in future cases to make sure that other public institutions like city councils or government offices also stay neutral on religious matters. And these are our references we used, and thank you so much.
Thank you.